Hi friends, this is CMA Deepika Bhugra Prasad, Insolvency Professional. I welcome you to Insolvency Insights, an illuminating snippet series curated by me. Let us together delve into some pivotal judgments under the IBC to navigate the complexities of the insolvency proceedings. Let us discuss one case today. So today we will discuss the case of Glukrich Capital Private Limited versus the state of West Bengal and others, Supreme Court. Now, what are the facts of this case? Glukrich Capital was unsecured financial creditor of Leading Hotels Limited, the corporate debtor, which was undergoing insolvency proceedings. Glukrich Capital filed a special leave petition before the Honorable Supreme Court challenging extension of the transit anticipatory bail to the suspended directors of the CD. The application was dismissed on the ground that Glukrich has no locus, as it was neither a party nor an informant in the instant matter. Glukrich again approached before the Honorable Supreme Court, vide an interim application for clarification. It was also submitted that it has been erroneously held in Sudipanath versus Union of India by Tripura High Court that Section 66 of IBC cannot be invoked against other persons, entities, or organizations with which there was any business transaction by the corporate debtor, but only the persons who were responsible for the conduct of business of the CD can be proceeded against. It is pertinent to mention that Section 66 of IBC confers powers on the adjudicating authority to pass directions against any persons to make contribution to the assets of the CD if such persons have knowingly been parties to carrying on the business of the CD with an intent to defraud creditors or for any fraudulent purpose. The Honorable Supreme Court said that Section 339(1) of the Companies Act refers to any business of the company which has been carried on with an intent to defraud creditors of that company. Obviously, the persons referred to in Section 339(1) of the Companies Act as persons who are other than the parties to the carrying on of the business in the manner aforesaid, which again refers to the business of the company which is being mismanaged and not to the business of another company or other persons. Let us understand the ambit of Section 66. Section 66 of IBC has evolved as a tool of recovery, wide the persons specified. The mandatory prerequisite entails delineation of the corporate debtor's business and examining if it has been carried on with an intent to defraud the creditors of the corporate debtor, or that the acts done are for a fraudulent purpose. The purpose behind the exercise of fixing of liability promotes the objects of the Insolvency Code. Above all, Section 66 limits the scope of inquiry of the Honorable NCLT to the persons specified above and establishment of mens rea to ensure that no frivolous proceedings are instituted against innocent parties. Now let us see the contrast in fixing of the liability within the corporate debtor. It is important to note the fine difference in the language used in Section 66, subsection 1 and subsection 2. Section 66(1) of the Code, prima facie, has a wider import inasmuch as it brings in its fold any person who was knowingly party to the carrying on of the business in such manner. On the other hand, Section 66(2) fixes liability upon a director or partner of the corporate debtor. It is relevant to note that a higher degree of threshold is required to be satisfied for any persons under Section 66(1) and a lesser degree inasmuch a director or partner is concerned under Section 66(2) for not exercising due diligence, which is contrary, and for a person to be held liable under Section 66(1), the person has to perform affirmatively. Now let us see what are the findings of the Honorable Supreme Court. The Supreme Court approved the view taken by the High Court of Tripura in Sudiparnath versus Union of India, wherein the High Court has held that remedy under Section 66 of the Code is not available against third parties. The Honorable Supreme Court has also held that remedy against third parties are not available under Section 66 of IBC, and that the resolution professional has to pursue civil remedies independent of Section 66 of the IBC. Honorable NCLT does not have the powers under Section 66 of IBC to pass any order against the third parties with whom the CD had conducted such fraudulent or wrongful business. The RP or the SRA under Section 66 cannot avail civil remedies against the third parties, which can be availed under other relevant applicable laws. Powers under these sections cannot possibly be utilized in order that a person who may be the head of some other organization be roped in and his or her assets be attached. The Honorable Supreme Court affirmed that the remedy against third party is not available under Section 66 of IBC, and in such circumstances, it is for the resolution professional or the successful resolution applicant to take such civil remedies against third party for recovery of dues payable to corporate debtor, and the civil remedies which may be available in law are independent of the said section. So the conclusion is that over a period of time, more and more intricate and complex transactions falling within the ambit of Section 66 of IBC are coming to the forefront. The need of the hour is to harmoniously read and construct the provisions of Section 66 in light of the object and purpose of Section 66. Section 66 cannot be read in a manner to either provide complete immunity to the third parties or to provide unfettered rights to the resolution professional or purchasers of avoidance application to seek recoveries from third parties without following the due process of law. So, friends, we see how the Honorable Supreme Court has clarified between Section 66(1) and 66(2). So, thank you for being here today with me. This is Deepika B. Prasad signing off, and we'll catch you in the next case. Thank you.